Now, still on this particular issue, I'm joined on the news by a legal practitioner, Toho Oseruvoja. He joins me from the United Kingdom. Toho, thank you for joining. Now, with the unfolding events in Kano State, what is the legality of the order granted by the Federal High Court?
Well, thank you for having me this afternoon. Well, if you look at it carefully, you discover that from the constitutional aspect, it has been argued that the Federal High Court does not have jurisdiction to hear issues emanating from chieftaincy or local government affairs, which is within the purview of the state. But however, there is a principle of law that works in every jurisdiction that is governed by democracy, and which is no matter how bad a court order should be, jurisdiction or no jurisdiction, it is the duty of everybody to accept such order. You may not agree with it, but you must accept it. And by accepting that order is to work in line with that order. So I'll tell you categorically, because we've not seen the substance upon which the order was granted. All we just saw is the said order. And if you look at section 251 of the Constitution of the Federal Republic of Nigeria 1999 as amended, you discover that, well, the jurisdiction of the Federal Court is clearly spelled out. But that should be the legal argument for both parties, for both councils who will be engaged for such services. But however, the order is still legal until it's set aside or it is contested and it is challenged. So that Federal High Court order still stands.
Now, can the recent order granted by the Kano State High Court overrule the earlier granted, directive by the Federal High Court, even though you insist that it still stands?
Well, this has actually exposed the weakness of the judiciary institution per se, if I may say. But if you look at it carefully, you discover that the Federal High Court and the State High Court are court of coordinate jurisdiction. When we use your coordinate jurisdiction, that means court of equal powers and equal rights, but are restricted by issue of jurisdiction as to the subject matter. Do you understand? And if you look at it carefully, it may be argued that the parties differ. The subject matter is not the same because this particular order is asking the police to evacuate the deposed emir and the 5 others, or they should evacuate their district. If you look at it from the legal point of view, you discover that it is basically the same subject matter. The same subject matter, because the rest in the issue is the emirship. Who becomes, or who is the emir of Kano, who is to stay and who is to leave. So I won't say it's an abuse of court process. There might be reason because the law develops every day. So we won't be surprised that maybe this will prompt further jurisprudence or further areas of law to be looked into. But the Kano High Court, the Kano State High Court order that was granted on the 27th of May, which was yesterday, cannot overrule. And let me make it clear to everyone. If there are equity in a particular issue, the first in time prevail, irrespective of how and who issued such an order. So I think as a lawyer, I think the Kano State High Court order cannot overrule the one of the Federal High Court. And if the police, let me use the word, if the police is to obey any, the first in time prevail. And if I say the first in time, which is you look at the one of the Federal High Court, which was granted on the 25th of May, and that has not been set aside.
So if I'm to take you by what you said,
yes.
You are saying that the police, which of course according to the State High Court has directed, the police to actually evacuate the army, to evict the army, to evict the emir from the palace. You are saying right now that they are not, in any way contravening the Constitution or the directive.
For the police not to act, like I told you, if there are two conflicting orders, the first in time prevail, and there's equal equity. When I use the word conflicting orders and equal equity, the two prevail. Because if those two orders are to be enforced, you see that anarchy will be let loose. and the law does not create that anarchy. That is where, like I told you, this has actually exposed the legal, that is the judiciary as an institution to see, okay, well, is it that this the other parties or the custodians of the temple of justice, which are the lawyers who are basically the key players now in these circumstances, would have advised parties on the appropriate step to take. Do you understand? But you could see that the police as an institution has their legal department, and they will work based on the advice of the legal department. And just like I told you, there are two orders. Which of them would they obey? Is it the recent one or the first one? And remember, these two orders are from court of coordinate jurisdiction. Though they are principles of law, if actually the order that the Kano State, that the second order of 27, if it's an order emanating from the Court of Appeal, obviously the police has no choice but to be bound by that particular order. But this order is coming from the State High Court, which have same coordinate jurisdiction, same powers like the Federal High Court. So the police will be at the liberty. I think the police have not breached any constitutional provision. Neither have they breached the statutory provision establishing the functions and the duties of the police. So the police are only acting based on the order they choose they want to work on. They have that discretion in these circumstances, because if you look at it carefully now, you could see that if they want to implement this and the next and this, and they have coordinated this, anarchy will be let loose. The police is not an institution that encourages such anarchy. I'm not speaking for them, but as a lawyer.
Point made, Toho. But in 30 seconds, before I let you go, this is a cultural stroke traditional issue. Do you see an avenue where this particular issue can be resolved in that line, as against going through, the route of the judicial system or, modern practices?
Okay, well, there's no way. If you look at 30 seconds, let me round it up. If you look at the northern Nigeria, and if you look at the era of the colonial regime or the colonial era, the successes recorded thus far in the colonial era is as a result of the monarchy system of government that is already in structure, that was already in place in the north. So you cannot take that from the north. But however, this has been overtaken by events with the advent of of democracy, with the advent of law. This too is now a status of law. It's not a creation of law. The law can let me use this word clearly. The law can decide. The House of Assembly can decide to say, okay, well, today we don't want any emirate in Kano State, and that stands. So there is no way it can be resolved without we looking at the law. Do you understand? So, but however, it behoves on the actors. Who are the actors? You look at the legislative, that is the House of Assembly members. Then you also look at the governor to look at how possible they can resolve this issue. Looking at long history of how the monarchy system has helped the North thus far.
All right, Toho. Thank you so much for your time on the news.
Thank you.